Hi, good evening, everybody. Thank you for joining our team at Fortis Law Corporation. And welcome to Fortis Conversations. The topic today is on family law, matrimonial challenges. Just before we start, just a few housekeeping details. I invite your questions to be typed into the comments bar, and I will raise these questions to the two Fortis lawyers we have here this evening. And if you wish to private message us, you can also do so. And basically, I'll just raise these questions to the lawyers later. We will try to answer as many of your questions as possible, but if we can't, please do contact us directly. Now let's get to business. If I could just have the slide. Thank you. Right. Let's meet our panel of two lawyers. We have Patrick Tan. He's a CEO. Yeah, the one who's waving is Patrick. He's the CEO and founder of Fortis Law. He's a practicing lawyer and a much sought after trainer and speaker. He's an advocate and solicitor, a notary public, a commissioner for oaths, a fellow of the Singapore Institute of Arbitrators, and an accredited mediator in the State Courts of Singapore and the Singapore Mediation Center. With us too, it's Berlin So. Berlin, you could just do a wave to the rest. Yes, hi Berlin. She's a senior associate with Fortis Law. She handles real estate matters and represents clients in family-related disputes, such as divorces and estate disputes. She also advises clients on matters relating to estate planning and incapacity issues. And I'm Jacqueline, Business Development Manager with Fortis Law, and your facilitator tonight. Thanks, Berlin. Okay, Tonight's topic, family law, and why we actually chose this topic, family law matrimonial challenges. This was actually specially chosen as we have received an influx of such queries during this period. Let me now just invite Patrick to just briefly introduce matrimonial laws in Singapore. Over to you, Patrick. Thank you.
Thanks, Jacqueline. Hi, good evening, everyone. Thank you for joining us on this Facebook Live. I must confess that this is like I think this is the first time we are doing this, but not the first time that we do matrimonial family law, of course. I've been in practice for 20 years now, and main staple of what I do is family law. So I've handled quite a number of cases in Singapore, local and regional clients. So as part of this program, right, if you have any questions like what Jacqueline said, you can always private message us, or you can actually type it into the chat group on Facebook, and we will try to answer all your questions tonight. Okay, so just to give everyone a broad overview of family law in Singapore, especially if we are talking about divorce or annulment of marriages and all this. Just to give you a broad overview, these cases, right, family cases are heard in the family court. So family court, it is located at Havelock Road in Chinatown, right? So we do have a family court situated over there. So all the family cases, they are heard over in that court. Now, just to give you a very broad overview of how one party or one person can actually start the divorce proceedings. Basically, your marriage has to cross a 3-year mark. So this is quite a noob thing that I have to share with you, because some of my friends actually ask me, if I'm married for a year, can I file divorce? The answer is no, right? So it's easy to get married in Singapore, not so easy to file a divorce. So within first 3 years of your marriage, you can't really file a divorce, unless you can prove exceptional hardship. All right, prove exceptional hardship. Now, what is exceptional hardship, right? Adultery or unreasonable behavior, later on I'll explain what these are, right? Alone, they do not amount to exceptional hardship. So you need to rojak all into one. Like maybe you beat your spouse every day, you commit rampant, or you are a serial adulterer, you put it all into one. Then maybe, just maybe the court will grant you permission to file divorce within 3 years of your marriage. Otherwise, it will be difficult. So you have to cross the 3-year marriage threshold first, right? And then you are qualified to file divorce. And of course, you have to satisfy that the court that you have jurisdiction, meaning that if you are Singaporean, your marriage is registered here. And of course, then the Singapore Family Court can hear your cases. However, if you are foreigners, you are PR or you live overseas, but for some reason you stay in Singapore for a period of 3 years, right? that also qualify you to actually file divorce. So it doesn't mean that foreigners or foreign residents, they cannot commence the divorce in Singapore, right? They can also consider filing divorce in Singapore as long as they fulfill certain requirements, residency requirements, all right? So assuming that you cross all these thresholds, you can then, of course, consider filing divorce. And if you have children below 21 years old, now it is mandatory, unless all the terms are agreed, for parties, for parents to actually go through what we call a MPP, Mandatory Parenting Counseling. So for that, you have to register. You log onto the website at MSF, Ministry of Social and Family, register for a slot and go for this 2-hour counseling session. They just want to make sure that, you know, the kids are protected, that you have made plans, you know, notwithstanding your divorce, you have made plans to look after your children, so on and so forth. So it is a 2-hour session. After you have attended this counseling, they will grant you a certificate. With that certificate, you can commence divorce in Singapore. All right. So just remember, if you have children below 21, they are very important. Children, it's very important. You need to sort that out. You need to get the MPP certificate sorted out before you even start, right, the whole proceeding. All right. Now, as far as the law is concerned, in Singapore, there's only one ground for divorce. One ground for divorce, which is that your marriage has broken down irretrievably. Only one ground. Character differences, you cannot, you know, each other, that one is really not the ground. All right, 性格不合, all this is not a ground. There's only one ground, that your marriage has broken apart irretrievably. And to prove this sole ground, there are 5 ways you can do it. 5 ways. First way, or what we call the first fact, is adultery. Right? Second fact is what we call, in our parlance, unreasonable behavior. Right? Third is separation, 3-year separation by consent. Fourth fact is 4-year separation without consent. Fifth fact is desertion, 抛弃, for a period of at least 2 years. All right, so you can rely on any one of these 5 facts to prove that one ground of divorce. All right, and basically get your divorce sorted out. All right, so remember 5 facts, and you cannot be the wrongful party, so-called wrongful party. All right, in other words, you cannot be the person who committed adultery and yet filed divorce. It doesn't make sense, right? You have to be the innocent party. All right, you cannot be the person who is unreasonable, who has committed unreasonable behavior, so to speak, and be the party to file divorce. In other words, you must be the innocent one. Okay, so these are really the broad grounds to start divorce. And divorce is different from annulment. Some of you may have heard of annulment and all this. What exactly is annulment? Annulment, basically, if granted by the court, means that your marriage has never taken place, you know, in the first place, right? That is called a void marriage, marriage, or we can also have a situation of voidable marriage, which is from the date the court grants the order, your marriage is void. So again, there are a few grounds that you can actually file for annulment, and annulment proceedings, you have to do it as soon as possible. You don't drag it out, So the moment that you know that you have to go for annulment, you have to file annulment. Usually within months or within a year of your marriage, you go for so annulment is different from divorce. In my experience, having done this for 20 years, right? The most common reason in my case, for annulment is willful refusal to consummate the marriage. Right? That means willful refusal to have sex post-marriage for whatever reason. That seems to be the most common ground for parties to actually file, in my experience again, for annulment. But before I continue, I just have to make it clear that, of course, this FB Live is not meant to be legal advice. Okay, it's not meant to be legal advice for you. Some of you may already have lawyers. Some of you may be going through divorce proceedings, right? Please do not take this as legal advice. It's just meant as some comfort for you. If you have any questions that you want to ask, right, feel free to ask. So please, just a disclaimer. Although we are qualified lawyers, I do this day in, day out, but please do not construe what I say as legal advice. All right? If you want, you can always engage me, call me. We can take this forward. All right? So that is annulment. So divorce, annulment. And a lot of people also ask me, is separation the same thing as divorce? The answer is no. Separation is separation, right? As I mentioned earlier, separation is one of the facts to support a divorce. It can be a 3-year separation by consent. The consent is usually evidenced by a deed. So both parties will sign a contract, right? And evidence that they will live apart for 3 years. 3 years later, they still have to file divorce formally. So it doesn't give you an automatic divorce. There's no automatic divorce in Singapore. All right. Or you can have a situation of a 4-year separation without consent. That means one party wants to separate, the other party for some reason don't want to separate. So you just live apart for 4 years. That is 4 years without consent. That is also one of the facts to file divorce. All right. So broadly speaking, we explain divorce and annulment and separation. Again, in my experience, why people go for separation, right? Because basically that is one of the facts for divorce. And also in my experience is that divorce is a drastic option. Sometimes parties may not be ready. And word of caution is that, I mean, we have to take this very seriously, right? Because we know that, divorce is a very it's very drastic. So we always advise parties to actually consider the whole matter carefully. If need be, try to salvage the marriage, right? Do not be trigger happy to file divorce, right? Try to save it if you can. Talk to counselors that, there's help all over. You can go to a family service center, talk to them and see whether it's possible to save your marriage. In other words, if you're not ready, right, do not contemplate divorce. Do not file divorce, right? So if you're not ready, one of the options, right, is to consider separation. So that gives parties a breathing space for a period of 3 years. I've seen cases that during these 3 years, parties can actually reconcile. So if they do reconcile, they will basically destroy the deed and live as per normal. Because once parties sign the separation paper, right, the court doesn't know, right? It is not a legal court order per se. It is merely a contract between both parties. So during these 3 years, right, it is sort of a cooling off period, right? So it gives both parties a chance. Maybe there's a chance to reconcile, right? So this is one of the reasons why people actually separate, right? And instead of filing for divorce. So broadly speaking, these are the grounds for divorce, annulment, right, in Singapore. But of course, once we go into that, we have to talk about other things, right? What we call ancillary matters. We have to talk about children, HDB flat, division of asset, and all these things, right? These are what we call ancillary matters. So in Singapore, divorce, you can see as two stages. First stage is about your marriage. So do not conflict the two. I always tell my clients, do not rojak the two. You bring in the divorce, the marriage, and your children and HDB, everything get conflated, you become confused. Try to be very clinical and say it as two parts. First part is your marriage. That to me is the most important part. Put your children, put the HDB flat, put your money, put whatever aside first. Focus on your marriage. Is it worth saving, right? Deal with that, right? Once that is sorted out, everything will follow. Then we deal with what we call the ancillary matters. Children, custody, care and control. That's another area that people tend to get confused. All right, they tend to equate custody, care and control as the same thing, but they are different things. For lawyers, we know that they are all different things. Custody means 抚养权, right? Who has the legal custodian right over the children? Who can be the father? Who can be the mother? Who gets to decide which school your children go to? What religion to adopt? That is different from care and control. Care and control means on a day-to-day basis who look after the children, right? Whoever had care and control has to afford visitation, right? What we call access to the other party. So custody, care and control, the 3 C's meant different things. So I see couples fighting over custody. At the end of the day, they are fighting over care and control. Not so much custody. Custody, normally, parents will get joint custody anyway, right? Very seldom parent will get sole custody of the children because it is not good for the children to grow up without a parent unless the parents really cannot make it. Otherwise, really it is healthier for children to grow up, under the custody of both parents, right? So there's custody, maintenance, division of matrimonial assets. Just to give you again a broad overview, for children, right? Basically, the court look into the welfare of the children as the paramount consideration. Welfare of the children is the most important factor that the court will consider. How about matrimonial property asset? Basically, how the court split, right? Generally, again, broadly speaking, 3 factors: financial contribution, direct financial contribution, indirect financial contribution, and non-financial contribution. Direct financial contribution is very clear. Who pay for that? Indirect financial contribution, as the name suggests, right? Indirectly. For example, your house, right? You pay for the reno, you pay for utility, maintenance fee. Although you didn't pay for the purchase price, you pay for all these things. That's indirect. Third is non-financial, length of marriage. whether you have been a good housewife, raised all children so that your husband can go out and make money, non-financial. So broadly speaking, these are the three factors that the court looked into when it comes to dividing asset. There's no such thing as straight away 50-50. Again, I hear my clients say, is it 50-50? Start from 50-50. No such thing. Maybe in other countries, but in Singapore, it's not say 50-50 straight away. All right? So this is what we call ancillary matters. Of course, ideally, both the divorce and the ancillary matters can be settled at one go. That your divorce will be very smooth and much more affordable. Otherwise, try to aim to settle as much as possible. Maybe settle on the divorce first, on the ground of divorce, or on the before you deal with the ancillary matters. So our approach at Fortis Law, we are not trigger happy. We always tend to believe that, when parties already reach this stage, right, the last thing they need is to really fight it out. They should try to resolve this amicably, right? So we always advise our client, help our client to get out of this as soon and as painless as possible, rather to get sucked into a long drawn, protracted, court dispute, court proceedings, right? So this is our law firm's approach. We try to help party and try to settle and resolve the matter amicably. Of course, otherwise, if not, we always stand ready to represent our client in very acrimonious proceedings, which personally I've done quite a number of them, unfortunately. So I hope that in the last 10-15 minutes, I have given you sort of a very broad overview of family law in Singapore, all condensed in the last 15 minutes. But really, that's all, I think. Over to you, Jack.
Thanks, Patrick. I think thanks for your very succinct intro and summary, and also words of wisdom. And I think I really like the fact that, that at Fortis Law, we really respect as much as we can the family unit, because that's really the core of society. And where we can, we do our best, to not go to the end where we can, and for the best of the situation. Okay, actually, so now let's have the conversations. I think we've got a question that's come in. The first question that we have is on divorce and the custody of children. So for divorce under unreasonable behavior, where the other party or female gender had an affair, but not enough evidence to prove adultery, and there's children below age 21. Why does the judge not take into consideration the party who admitted to having an affair, and yet the party is able to fight for care and control of children? That's the question.
Okay, I'm trying to understand the question. Correct me if I'm wrong. The question seems to ask that if let's say the other party, the wife, female gender, had an affair, although we didn't have enough evidence to prove adultery. Yeah. Why doesn't the court take that into account, that she had an affair and she should be denied care and control of the children? She's a lousy woman, she's a bad person because she had an affair. Well, basically, again, in my experience, she might have committed adultery, right? But she might be a good mother. It's two separate matters. I can be a lousy wife, but I'm a very good mother, right? Just like I can be a bad father, I can be a bad husband. I don't love you, but I love my children, You know what I mean? So the court is very clinical. Like I said, when it comes to care and control of the children, the court look at what is the most important welfare, what we call welfare consideration for the children. But of course, if you can link that, the fact that the female gender, the wife had an affair, and that somehow made her unsuitable as a mother, or somehow you can link that with her, her conduct being detrimental to the welfare of the children, then maybe, yes, the court might take that into account. But in most cases, it is quite a separate matter. Again, in my experience, right? I'm only speaking from my experience. In all the adultery cases that I've handled, although the party had committed adultery and all this, somehow they are still a decent parent, to their children, right? So it is hard put for the innocent party to convince the court that, just because my spouse had committed adultery, therefore she's not qualified to look after. In fact, in my experience, the contrary is true. In my experience, I've seen spouses who had committed adultery, in fact, are better parents than the innocent spouse,
Why?
Outside, they may have a boyfriend or girlfriend, but when they come home, they look after the children much more than the innocent spouse. Then what are you going to say to that? Correct or not? Sometimes it can happen. They can multitask, right? Outside, they can have an affair, but when they come home, they actually look after the children from top to end, you know, put them to bed, send them to school, you know, look after them, shower them, cook for them. And then once the children are settled, go out and have an affair. Then how? Correct or not? So there are many different considerations when it comes to care and control. But the most important consideration is what is in the children's best interest, welfare of the children. Adultery or unreasonable behavior alone per se, you know, is not a sufficient factor for the court to take into account to deny the wrongful party of care and control of the children. All right.
Okay, thank you. Thank you, Patrick. Another question has come in. Perhaps Berlin, you might want to look at it. I have a question regarding family law. Would explicit WhatsApp messages count as evidence towards adultery? Either Berlin or Patrick can answer this question.
Which one? The WhatsApp messages, is it?
Yes, would explicit WhatsApp messages count as evidence towards adultery?
Of course. Let's say the WhatsApp messages, oh, I love our sex last night, you know, I love it so much, you know, can we spend more time having sex, you know, just like before, like every night? I mean, that's quite clear, isn't it? Adultery means penetrative sex. Huh? Whole hand kissing is not adultery. So the question is whether WhatsApp messages, yes, it counts. Maybe in the WhatsApp, this is what we call admission, in fact. It's admission, you know. The spouse had admitted to adultery. That is a strong evidence for adultery. Of course, you can have video. If you have video, even better, right? Or photographs and all this. But WhatsApp is good.
Yeah, it depends on the content of the WhatsApp messages, right? On the day.
Yeah, so explicit, must see what explicit lah. Like if it's explicit in the way that I described earlier, then I think it's good. And which we have seen, very explicit WhatsApp messages, videos, and whatnot.
Okay, all right. There's another question. Thank you very much, Berlin and Patrick. Another question. I'm in the midst of applying for Singapore citizenship. Does it affect my application? Should I file for divorce?
Berlin, or you want?
The grounds of the citizenship that they're applying for, right? I believe.
The basis, I mean, the PR, I mean, basically, how did they get their PR? Because to get the Singapore citizenship, the basis is that you're already a PR, right? So how did you get your PR? Is it, I mean, like basically, is it piggyback on your spouse? You know, being a Singapore citizen or being married to one. So, or your PR is basically on, you know, piggyback on your employment, right? So we have to see the basis for your PR, right? To say that it totally has no connection or it doesn't impact your citizenship, you know, I think it is not correct to say that also. But as to the extent of how much it will impact your application, we have to see. Right, how the basis for your PR, right? First, so we have to be very cautious when it comes to this. Again, we have seen many cases like this, okay? Because nowadays, I mean, we have foreign spouse and all this. Right? It is a common question.
All right, thank you. And this question came in, was sent to us earlier. Is on matrimonial property. Both husband and wife own a private property under joint tenancy. In the final judgment, both parties agreed they will sell the property if both parties agree. Now party A wants to sell, but party B isn't keen. Can party A do anything?
I think if the court order says that it is dependent of both parties agreeing before the property can be sold, then definitely we will have to look at variation of the court order in the first place.
We have to change the court order. In the first place, the court order said that if both parties agree can be sold. Wow, that's already got problem already, right? So if both parties don't agree, that means cannot be sold. And now one want to sell, the other one want to sell. So how to settle? Go to court already, no? Correct or not? Because otherwise it's jam already, no? So you got to go to court and settle it. What Berlin said is right. The application of variation of the court order, right? Basically, what you want to vary is to tell the court, now I want to sell. You know, my ex-spouse don't want to sell, you know, not giving me problem. Either she buy my share out or we sell in the open market. Otherwise, we jam, you know. So the application is called to vary the court order.
Okay. All right, thank you. I think there's this question follows from the earlier citizenship question. It's not, if it's not a piggyback application, right? If the Singapore citizenship question is not a piggyback application.
Okay, honestly, okay, if you were ask me from a matrimonial perspective, I don't think it should affect. But then again, I'm not ICA, you see. Right, I mean, like in your citizenship application, you may need to state that, you know, are you married, are you single, are you divorced, and all this. So honestly, I mean, if you are divorced prior to your application, then you have to state that you are divorced and recently divorced for that matter. So whether that would affect your application really is anybody's guess, you know. But if you can wait, then get your citizenship first, you know, to be 100% safe, right? Then we file the divorce rather than, you know, so it's really it's a matter of priority, isn't it? If you have already filed for your application for citizenship, and I would strongly suggest you wait for the outcome of the citizenship application, because I really, as your lawyer, right, let's say I would not advise you to take that risk to file divorce and, you know, and for some reason, ICA or whoever came to know about it, or your ex-spouse came to know about it, and then write a nasty letter to immigration or to the authorities and say that, well, my spouse is not of a decent background, and she's not fit and proper to hold a pink IC, and all these complaint letters, what we call poison letters. I really don't want that, you know. I don't want you to take that risk. So I would rather that you get the citizenship first and then file. Safer that way.
Okay, thank you. Another question has come in, I think, on assets. If I transfer my assets to my children, will these assets be considered in the divorce proceeding?
It really depends on what do you mean by transfer. So can I give an analogy? Is that if you were to transfer your assets to your friend, basically try to what we call dissipate assets, then of course that will be taken into account in your divorce proceeding, because you're trying to defeat your spouse's claim, you see. So it really depends on what you mean by transfer your assets to your children, and why are you doing that right now when you are filing for divorce. That is a big question mark, you know, that your spouse may want to know, may want to ask also. So really, we need to know, what do you mean by transfer your assets? And why do you want to transfer your assets now? Why don't you do it together as part of the divorce proceedings? At least it is transparent. So if you want to really give your assets to the children, tell your spouse, now we are splitting, right? You know what? Let's not fight over this. All these assets that we have, we give to our children, steady or not. Put it in, be transparent, rather than to do it behind her back. Transfer to your children, transfer to your friends, and then you file divorce. Later, kena found out. Kena. Correct. So it really depends on what you mean by transfer, how you do it, and all these things.
I think there was this, I think related to this question, there was a question given to us earlier, how to protect assets under the individual name if the marriage ends in a divorce. Is it related?
Okay, I mean, it is quite a broad question, right? I mean, if we are talking about protecting your asset, I mean, like, if you're talking about preemptive strategy, then you may want to consider what we call a prenuptial. I am sure you have heard of this prenuptial agreement. That means before you are married, you know, you can actually enter into this agreement with your girlfriend or fiance or boyfriend, and basically say something like, you know, well, we're going to get married, but you know what? All my assets are mine. Yours are yours. If we split, you don't come and claim against mine. Although strictly speaking, not binding on our courts in the event, but it is strongly persuasive. You know, it is strongly persuasive. So that is what we call prenuptial agreement. But you can also do something like a postnuptial agreement. So let's say you're already married, right? And somehow you have this feeling that a few years down the road, your marriage may end up in a divorce, right? So you want to preempt, right? So you can convince your spouse to sign what we call a postnuptial agreement also. Again, not binding on the courts, but strongly persuasive. Get your spouse to sign something, say your asset is your asset, my asset is my asset. And then, of course, the third strategy is what we call a bit more complicated, is to put your asset in a trust. You ring fence your asset. Okay, that will take me another 3 days to explain. But basically, trust is that you put your asset, the legal ownership of your asset, into the name of a trustee, a third party, who then hold the benefits of the asset for you or for some other people. because the assets are no longer legally yours, in the event there's a divorce claim, right, proceedings, that assets will not be part of the equation. But of course, if you do this trust in an attempt to defeat your spouse's claim, then the trust will be set aside. So it is all about preemption. It is all about planning ahead, right? So before you get married or before you even contemplate divorce, right now, if you think that, well, who knows, right? 10 years, 20 years down the road, who can, predict? If you have this concern, then these are the three things that you can do, you can consider doing to ring fence and protect your own assets. All right?
Maybe I can also add on, like maybe in the event that you are planning to get married but you're not married yet, you can also consider separating your assets, your premarital assets. Because your assets prior to your marriage will not form part of the matrimonial assets. That is a question as well.
That's right.
Okay. All right, thank you. I think there was also an earlier question about the trust deed, which you mentioned, Patrick. And the question was, can a trust deed protect the assets from being divided when divorced?
Yeah,
right?
because
So,
once assets is put in the trust,
yes,
it belongs to another person.
Yes. Okay, thank you. Yeah. Okay, I think this is really the first question that came was, do I really need a lawyer when I file for divorce? First question that was asked, actually. Yeah.
Yes and no. Legally, you don't need if you know what to do. Legally, you don't need if you know what documents to prepare, how to file. But really, unless you really know the whole process, I would strongly suggest that you engage the help of a lawyer, because beside processes and the documents, right, we all know that divorce proceeding is not easy. In fact, it is one of the hardest court proceedings that anyone can go through. It is emotionally draining, right, physically tiring, right? So I would not suggest that you go through this alone, right? Let your lawyers do all the heavy lifting, right? That is why you hire the lawyer. I mean, you are already going through a very difficult stage of your life. Why do this on your own, right? You don't have to do this on your own. That is assuming that you even know what to do, right? So even for lawyers, for lawyers who are going through divorce, I always tell them, don't do this even though you know how to do it. For lawyers, I always tell my lawyer friends, if you're going through divorce, get another lawyer to represent you. Because once you are caught, even if you know the processes, you may be all confused, because you're so emotionally, entangled. You may not be able to think straight, So it is not easy. So this is one area of law that is not just about, it's not clinical at all. We're not talking about money here. We're talking about emotions, talking about children. So even if you know the processes, you know what documents to file, please don't do it. Let alone if you don't know. Get a lawyer.
Okay.
It's not easy.
I think even for simplified divorces, I think there's around 5 to 7 documents to file just for the case.
And we don't say this because we want to earn your money and all this, because really I've done so many of these cases, right? I can tell you it's not easy. Every case that we do, all this family case, is not easy at all. Really, the emotional aspect. I can see the pain that all my clients go through. Right? So don't do this alone.
All right, thank you. And there's another question that's not related. It's on family violence, actually. I think, in the Fortitude budget that was announced on Tuesday, I think Mr. Heng did mention, that they are seeing an increase in domestic violence as well as matrimonial challenges.
Yeah.
This question was asked earlier. What can I do when I'm facing family violence?
Berlin, want to take this?
I think the first thing you should do is also make sure that you have a police report and medical report. Once the violence happened, collect evidence of all this violence situation, violent behavior from your spouse. Then immediately, as soon as possible, go to the Family Justice Court and the PPO department and file your case immediately. So if the judge feels that your case is very urgent and that you require a protection order, they will give you an expedited protection order. Then thereafter, they will also follow up with protection order trial for your case to be heard. So this violent situation is, I think it has been increasing the past few weeks, especially during this circuit breaker.
Yeah.
So Alternatively, you can also file it on IFAMS, which is the Family Court website. So those are the options that you can do.
As you can see, Berlin is my very able lawyer, right? Very calm, very collected. This is the kind of lawyer you need, you know, in times like this, who
Okay.
actually provides some sense of stability, calmness, and clarity. Not like me, a bit agitated, right? A bit emo, right? But Berlin is a sense of calm, right? So she handles quite a fair bit of family law also.
Okay, thank you very much. Yeah, I've got lots of confidence in both Patrick and Berlin. Yeah. Right, another question has just come in on, I think, divorce. An expat couple who filed for divorce. Wife is on dependent pass while children are studying in Singapore. Does the wife have any grounds to fight for the children when she does not hold a permanent job, and if it is the husband who has committed adultery?
Okay, again, I say we have to be able to see these issues as separate issues, right? Adultery goes towards the divorce, all right? And then you see in this question, you know, there is, you know, adultery and trying to link it to care and control of the child and all this thing. We have to be able to separate them, all right? The husband had committed adultery, so that goes towards divorce. And now if we are talking about children, does the wife have any grounds to fight for the children? I take it that whether the wife can have care and control, being on dependent pass in Singapore, presumably unemployed, you know, dependent pass, you cannot work, can only look after baby, right? And then your husband is the only one who work in the expat bank, multinational, right? Standard one, standard. We have done quite a number of expat cases, all like that. Expat wife, stay in Singapore, dependent pass, never work, look after children. Married the husband who works in Singapore. So basically rely on the husband. And then the husband outside got girlfriend, right? Then how? Very classic, right? This is unfortunately it's a very difficult area. Again, I've handled cases like this, cross-border, you know. I mean, we're only talking about Singapore expat. I've done cases involving multiple countries. Husband and wife from different country, baby born in another different country, and then all somehow stay in Singapore, right? It is not easy. Unfortunately, this is one area that is very difficult. To answer your question directly, does the expat wife, you know, have any ground to fight for the children when she does not hold? The answer is yes. She has a right, right? Question is whether she can win or not. And win is what is considered a win? These are questions that we need to ask. As the wife, as the mother of the children, of course she can fight for care and control, custody, care and control of the child. Now the question we need to ask is what kind of care and control does she want? And that is a difficult question because the point is that she is a dependent pass holder staying in Singapore, presumably without any income. The larger question is that if she split from the husband, will she even be able to survive, you know, put her children aside, you know what I mean? Because she is not gainfully employed in Singapore. Whether she can even stay in Singapore is a question mark because she is a dependent, right? So after the split, she's no longer a dependent. Can she still stay in Singapore? If she cannot stay in Singapore, will she be going back to her home country, right? So before we even talk about whether she has the right to fight for the children and whether the children can go with her or go with the husband, we need to ask all these questions first, right? First thing, does she have money? Can she survive on her own? After the split, where will she be? Will she continue to stay in Singapore on what path? Nobody knows. So is she going to get employment on her, you know what I mean, herself after the split from the husband? Maybe she can get an employment pass, get a job and all these things. All these are related questions that we need to find out first before we even talk, because at the end of the day, if we go and fight over care and control of the child, these issues will surface. The court will say, now you're not even a dependent, right? After the divorce, you may need to go back home after your visitor pass is over and whatnot. Then what are you telling the court, telling us they're going to bring the child home? Right? Or are you going to continue to stay in Singapore and work, get an employment pass, maybe even get a PR in a bank or whatever, work in a bank, and then you have income of your own, and then you want the child to stay with you in Singapore? So all these are related issues that we need to deal with. There's no clear-cut answer to say, oh yes, you know, definitely the child with the mother and all this, right? But if you were to ask me, can the mother fight for the care and control? Yes, legally can. But as to how this will pan out, we have to deal with all those issues that I mentioned first. Okay?
All right, thank you. Just before I go on to the next question, we have just flashed our contact slide. So if you need our contact details, is there. And do feel free to take a picture of this slide for your easy reference. Okay, the next question is, if someone is suffering from narcissistic abuse by the other party, will the judge take into consideration such abuse?
For what? Divorce?
Is this for divorce or?
If it's divorce, definitely that comes under unreasonable behavior. Again, I've come across cases like this. Wow, very sad one. Right? So this will go towards the ground for divorce. So the court will definitely take that into consideration. In fact, that will be the key factor to prove your divorce.
Okay.
Like what Berlin mentioned, do not suffer in silence, you know. If you are being abused, remember to go and seek protection, right? There's a lot of help, you know, available in the community. Please go and talk to somebody, talk to a counselor, go to the police, right? Go and get protection. Do not suffer in silence. All right?
Okay. Yeah, thank you. And the question here is, if the spouse files intention of divorce twice, does it affect anything if the other party files for divorce?
I'm not sure what intention for divorce.
Yeah, what's intention of divorce? Not too sure about that. Never heard of that, you know, intention of divorce.
Maybe he started divorce proceedings, but maybe discontinued. Later on.
Yeah, okay, then the question, does it affect anything if the other party file for divorce? No, I don't see, I don't think it affects anything. The other party can always file divorce. Maybe the other party say enough already, you misfire twice, or you know what I mean, you fire blank twice already, so now it's my time to fire, this time confirm real one. Because so far you say intention of divorce, right? You filed twice, but nothing happened, right? So that's firing blanks, right? So it doesn't affect the other party to file.
Okay. All right, thanks. Another question here is it true that possibility of men getting care and control of children upon divorce is slim, given that women are protected under the Women's Charter Act? You could answer that question to some extent earlier, right?
Berlin?
I think the short answer is no. I don't think the Women's Charter prevents the men from getting care and control of the children. And nothing in the Women's Charter would say that as well. At the end of the day, it's based on the child's best interest and what is in the best interest of the child. If the man can take care of the child way better than the woman, maybe the woman parties every night or goes clubbing every night, then I don't see why the man would not get care and control of the children. It's that simple, actually.
Yeah. I think the thing is that don't be misled by this name, this title, Women's Charter Act, and think that it is all about women, you know. Like what Berlin said and what I said earlier, right? When we talk about children, we really look at what is in the best interest of the children. The welfare consideration is paramount, right? So don't be misled by this title, Women's Charter, right? So as to the question whether it's, you know, the possibility of men getting care and control is slim, it's not really the case, you know. I mean, I've seen men getting care and control. In fact, now I'm seeing women giving up care and control of their children. They don't even want it now. Right? They say, can you ask my husband to take the children? I want freedom, you know. I don't want, you know. Nowadays, it's not that, you know. Now, the women also don't want, you know. In my experience, this is becoming more and more common for some reason, right? Care and control. So it is, but in my experience, again, if the child is very young, right? The child is like baby, you know, or 1 month old, then you ask the man to have care and control, man cannot be one, right? How to breastfeed? So, I mean, like if the baby is very young, right, still breastfeeding, right, of course, care and control, if let's say you split, then care and control, of course, go to the mother. That one is biological, right? Again, we are not because it's Women's Charter Act or because we are pro-women, you know. It's biological, it's physiological, right? The children of the age are closer to their mom because they need to breastfeed also. And it is really in the best interest of the child, right, to be cared for by the mother. But if, of course, we are talking about your child being like 18 years old, no, rascal already, there's a different story. Like, it can go either way, right? Can go, that time, the court may even ask for your child's comment, you know, or his views about whether they want to follow mother or follow father, right? So it really depends also how young your children are, no? At what stage, right?
Okay. I think there's a question on, I think there was an earlier question which you both answered, I think, on intention of divorce twice, and you said there's no such document, something like that. I think he meant intended divorce proceedings. Is that such a document? Yeah, intended divorce proceedings.
Maybe they send lawyer's letter to the other party saying that they intend to proceed with divorce proceedings. That's the only thing I can think of at this point.
Okay, so I hope that answers.
Yeah, short answer, it doesn't affect the other party filing. Yeah, you have intended to file twice, but that wouldn't affect the other party from filing.
Okay.
There's a follow-on question here, right?
Yeah, there is. I think this was under the Women's Chartered Act, right? That I think you just replied earlier. He said that what I heard is that children will always be close to their mother, and mother has the priority. That's what this person has heard here.
I mean, I'm no psychologist here, right? I mean, yes and no lah. I mean, my children are close to me also, right? So I don't think that children, is like confirm or always close to the mother, and mother has the priority. But like what I said earlier, if the child is very young, is an infant, of course, physiologically, biologically, will be closer to the mother because they need to be breastfed and things like this, right? So that, I mean, if the children are already teenagers and, of a certain age, then it may not be true that, the children are closer to the mother. They may be close to both parents, right? They may be close to both parents.
Yeah, I think this person has added on that his children are 4 years and 11 years old.
It really depends, right? Yeah. I mean, I also have children, 4, 7, 9. They're close to me also. I hope so. Right.
Okay.
By the way, it's my daughter's birthday today,
Yeah.
Yeah, I just cooked for her. So you see, wow. I'm close to her, she's close to me.
Very good father. Very good father. Okay, thank you. So I think we have time for just one last question. Okay, and the question is really on CPF monies. And the question is, are CPF monies automatically do they go to the spouse when one gets married? And can he or she change the nomination to his preferred choice?
This is in terms of what? Estate, is it? In the event that the person passes away.
Nomination is nomination,
Yeah.
Nomination is when you die, who you want to give your CPF monies to. Not divorce. Divorce happened before you die. Right? I mean, it sounds common sense, but just have to clarify it, right? So when we talk about CPF nomination, we are talking about who do you want to give your CPF money to after you pass away. And please go and do your CPF nomination. Now you can do online, by the way. Go CPF website and do it online, since we're on that topic. But if you're talking about how CPF monies will be split or whether it can be split upon divorce, right? Then Berlin, maybe you can share with us about CPF monies in relation to divorce.
The simple answer is it cannot be split, but the more extensive answer would be during the divorce proceedings, the CPF monies will form part of the matrimonial assets. This means that when you call in all your monies from division, all your matrimonial assets means all your assets from one spouse plus the assets of the other spouse, will put all of them together before dividing for divorce purposes. So the CPF monies will form part of the divorce matrimonial assets for division. But physically, your money still belongs to you in your account.
Yeah.
Can you put a charge also on the other party's CPF account?
I don't think so.
Can put a charge order,
I think yes, correct. You can take monies from the other party in the divorce order.
Yeah.
So the question was, the CPF money automatically go to the spouse when married? So the answer
no automatic one.
Yeah, the answer is no. Okay.
No automatic one.
Yeah. Okay. So I think basically we have come to the end for all the questions that we've received. And thank you so much for putting your questions as well in the chat in the chat group as well. I just want to thank Berlin and Patrick. Thank you for your time and for your clarity of answers, and also for all of you for making the time to join us tonight. Really do follow and like us on Facebook and LinkedIn, because we have lots of updates on really good content that we share with you and with our partners, content in different areas, in the areas of estate planning. And today it's our first time doing on family law, and also content on real estate related matters. Really, really great content. So do follow us on Facebook and also on our YouTube channel as well. We have done really nice, short, sharp videos, very topical issues on talking points in the current COVID situation. And our YouTube page is, I think, Fortis Law Corporation. So do check those videos out as well. And if you wish to actually receive updates from us, also go to our website and just subscribe and just put your name down, and you'll be really informed of what's happening. So quite a lot has happened actually these 2 months during the circuit breaker month. So I just want to say a great thank you to Patrick and to Berlin.
Thank you. Thank you, everyone.
Yeah, I've learned so much this evening, and I just want to wish everybody as well a lovely weekend. And we hope to be able to see you or to speak with you at some point in time. Thanks very, very much.
Thank you. Have a good weekend. Stay safe. Thank you. Bye-bye. Bye, everyone.
Bye.